a morning work session of the Portland City Council. Today's date is October 1st, 2019. Today's work session is going to focus on community concerns in police union contracts. We're joined today by both DeRay McKesson and Samuel Singh-Yahweh of Campaign Zero. Campaign Zero's goal is to reduce police violence in the United States to zero through the adoption of policy proposals informed by activists, the President's Task Force on 21st Century Policing, recommendations from research organizations, and comprehensive data on the causes and impact of police violence. DeRay and Samuel are here to provide their perspective. And for everyone listening, I want to be clear, we're here to hear their perspective. Their views may or may not be in alignment with individual members of the council. Campaign Zero was invited here today by Commissioner Hardesty as part of a larger collaborative effort amongst the City Council. This process is very important. Because I've said previously, it's worth noting that 3 of us on this council were not involved in prior negotiations around this contract. So we have a lot of questions and a lot to consider. It's the city's goal to ensure a meaningful negotiation process that results in a contract that supports our officers and serve the interest and welfare of the public. We will listen to any and all data-driven information that can help us achieve that goal. As mayor, I'm committed to ensuring a process where the City Council can hear information that will both benefit the communities and our understanding of the collective bargaining process and best practices. As police commissioner, I'm committed to bargaining in good faith and ensuring a fair, unbiased process for negotiations with the Portland Police Association so that we may come to a successor agreement. Because we're about to embark on contract negotiations with the Portland Police Association, we're mindful of the legal risks of holding a work session of this nature. To that end, I've agreed on this work session being held with certain parameters in place. Here are the ground rules that the council has agreed to. Number 1, first and foremost, we are not going to talk about the PPA contract. That means that bargaining strategy will not be discussed here today. The bargaining priorities will not be discussed. The specific provisions of the contract will not be discussed. To the extent the conversation begins to veer off course, I've instructed the city attorney's office to redirect. Number 2, I've also asked legal counsel to interject if anything placed on the table or offered for consideration contravenes Oregon state law. To that end, prior to the presentation, the city attorney's office will give a brief primer on collective bargaining in the state of Oregon to place today's conversation within context. Before we get started, I'd like to give Commissioner Hardesty and Chief Outlaw the opportunity to offer a few remarks. Once they've done that, Heidi Brown from the City Attorney's Office will give a primer on collective bargaining in Oregon. And then finally, we'll have the opportunity to hear the presentation from our guests today from Campaign Zero. And we thank them for being here and we welcome you to Portland. Commissioner Hardesty.
Thank you, Mayor, and thank you, colleagues. I want to first start off by thanking the Mayor and my City Council colleagues for being willing to have a primer on police contracts nationally and what best practices look like, because I think this is a wonderful opportunity for the City Council to collectively ensure that we are in fact implementing best practices throughout the city in every bureau that we have. I want to also thank our guests, DeRay and Samuel. They've done extensive work all across the country, and we're going to get an opportunity to talk about that today, which really excites me. This work session is an important opportunity to make sure that the public and our officers are educated on what national best practices are. As our city and communities continue to change and evolve, I want to make sure that we are utilizing data and research to make decisions that reflect 21st century public safety and community policing principles. I am glad to, again, that we have this opportunity today here at City Hall. I want to thank the community for showing up and for those who are live streaming. We've been having this conversation for 2 decades at least, And so I look forward to seeing what we learned today and how we can put best practices into practice. Thank you.
Chief Outlaw?
Thank you. Good morning.
Morning.
PPB, can you hear me?
Yes.
Is that mic on? I'm not convinced that mic's plugged in. Let's try the other one.
How about now?
Much
Good morning,
better.
thank you.
There you
All
are.
right. PPB officers are on the front lines responding to emergency calls for service in our community, as we all know. In their duties, officers strive to ensure the safety and protection and the rights of all of Portland's communities. I support a fair and objective process for bargaining for all of our members, but I also believe it's important to hear from varying perspectives to ensure any blind spots are addressed. Our current staffing shortages and anticipated retirements present an urgency on concluding good faith contract negotiations as soon as possible. So I'm hopeful that our negotiations result in a PPA contract that is in the best interest of all stakeholders, not just our members, not just our community, but all stakeholders, to ensure that we are a competitive employer of choice. Thank you. I look forward to our session today.
Good morning, Mayor, Commissioners. My name is Heidi Brown. I'm an attorney with the City Attorney's Office, and I'm going to provide a basic overview of Oregon law on collective bargaining for public employees and public employers in Oregon. So Oregon law gives public employees the right to be represented by unions and to collectively bargain. Under this law, both the public employer and the union can demand to negotiate about employment relations. This is a concept that involves matters concerning direct and indirect monetary benefits, such as wages and health insurance. It includes hours, vacation, sick leave, grievance procedures, and other conditions of employment. And that's the legal definition under the Oregon collective bargaining law. Oregon's legislature adopted this law to require public employers and public employees and their unions to go into bargaining with a willingness to resolve grievances and disputes that relate to those issues that I mentioned about employment relations, as well as to promote the improvement of employer and employee relationships. One aspect of Oregon law is the requirement that public employers and unions bargain in good faith. The Employment Relations Board, which is the agency that is tasked with interpreting Oregon's collective bargaining law, more often discusses what is bad faith bargaining rather than what is good faith bargaining. And the board will find bad faith bargaining in two circumstances. One is when either the employer or the union's conduct is considered so harmful to the negotiations process that it is a violation of its good faith bargaining duty. And then the second is when the totality of the union's or the employer's conduct during negotiation indicates an unwillingness to reach an agreement. Some of the examples that the board have given that indicate an unwillingness of this sort are tactics to delay, contents of proposals that suggest a party is not trying to reach an agreement, the behavior of the party's negotiator, nature and number of concessions that are made at the bargaining table, the failure to explain a bargaining position, and then the course of negotiations overall. When public employees and unions bargain, but they are unable to come to an agreement on what the contract will say moving forward, there are two processes available for unions. One is for union members to go on strike, and then the second is for the parties to go to something called interest arbitration, which is a hearing. The interest arbitration is for unions that the law prohibits from striking, and those include fire, police, and 911 emergency operators. Since 1995, interest arbitration in Oregon is different from most other states in that it is a win or lose system. So 2 weeks before the hearing, each side has to provide what's called their last best offer. In most states today, the interest arbitrator can pick and choose different pieces from each last best offer. But in Oregon, the interest arbitrator has to pick everything from one side. When this process was adopted by the Oregon legislature, the reasoning behind it was to try to get each side to give their most reasonable offer because the risk was that you would lose on everything altogether. Another thing to know is that when a party requests something, an interest arbitrator will often expect to see something of value offered in exchange for that request. While there are many things that can be bargained, there are some things that are prohibited from bargaining because they're controlled either by the Constitution, the Oregon or U.S. Constitution, or they're controlled by state law. So just an example, under the Oregon Constitution, most public employees are entitled to due process both before and after either a loss of pay or loss of their job. And then there's a state law that's specific to police officers that impacts bargaining, which is the State Officers' Bill of Rights. And cities and counties are not allowed to go below those minimum requirements that are in the Officers' Bill of Rights under state law. So one example, just so you have a sense of what's covered by the Officers' Bill of Rights, is a provision that says that a police officer is not required to answer questions until the officer has been informed of the nature of the investigation and of facts reasonably sufficient to inform the officer of the circumstances surrounding the allegations under investigation. So those are just a few examples of certain matters that cannot be bargained. Of course, keeping in mind that many, many matters can also be bargained and are open for negotiations. And then I'm happy to provide further information about the legal requirements in Oregon at any time during today's discussion. Thank you.
Very good. Thank you. Gentlemen, the floor is yours.
Where is this? Where will this be presented? Where's the screen?
That you'll see?
Oh, we're not seeing the screen,
So what we can do is,
can
we'll just
move.
move so
Okay.
that we can see the screen during your presentation.
Cool. So we're excited to be here today, excited to have a conversation about the police union contracts and contracts in general, best practices. It's good to be back. I previously have had conversations with the mayor and Chief Outlaw about some of these issues a couple years ago, but not a formal presentation. So it's good to be here and be back. Before we begin, we'll just introduce ourselves. So I'm Dre McKesson. I am an activist. I was formerly the Chief of Human Capital for the school system in Baltimore, and I managed all of the implementation of all of our bargaining unit agreements for the unions, and then also I was a Senior Director of Human Capital in Minneapolis Public Schools and also managed the implementation of our collective bargaining units there.
And it's great to be here. My name is Sam Sinyangwe. I'm a data scientist. My background, before getting into this work in 2014, my job was to help support 61 federally funded communities under the Obama administration's Promise Neighborhoods program to build out data systems that could track the provision of services and supports to kids and families in poverty, using data as a tool to hold institutions from schools to organizations accountable to delivering results for kids and families. That is the approach that you will be hearing today, using data as a tool to better understand and address issues that impact communities.
So importantly today, we are not coming with a set of recommendations about the city of Portland. We're not necessarily coming with a set of recommendations about police union contracts. We are here to talk about best practices that have been informed from an understanding of the data around use of force in communities and also some of the newest research that has been done about police union contracts or provisions in contracts or found in policy notably around use of force, but contracts around the country and laws, has already been stated by council, impact so many of these things. We will start with Sam helping us understand the data. So we started with a large analysis of data around force around the country that led us to focus on police union contracts, and we'll talk about that specifically about how we got there, and then policies.
Great. So if we could get the presentation up, perfect. So one of the things that we started with this work was really trying to understand in 2014, in the early days and weeks and months of the national conversation around policing and police violence, there were some fundamental questions around police data. In particular, as we saw communities take to the streets demanding accountability and justice. What we learned was that there was a lack of data on policing in general and in particular around use of force. Even some of the most serious forms of use of force, for example, police shootings, use of deadly force. The federal government could tell you how much rainfall there was in rural Missouri going back 100 years. They could not tell you how many people the police had killed last year or the year before, let alone all the other forms of use of force that impact communities much more frequently. unfortunately. So we sought to address that gap in the data by collecting and building the most comprehensive database of people killed by police in the United States called Mapping Police Violence. We relied on information obtained through public records requests, information obtained from local media reports, from existing databases that were partial but together could be merged into a more comprehensive set, information that could be obtained from criminal records databases, from obituaries, and a range of other sources to build this database. According to best research estimates, we have about 98% of the total number of people killed by police captured in this database. And we launched with this map. The map depicts nearly 1,200 people who were killed by police in the year 2014. Every single year, there are between 1,100 and 1,300 people killed by the police, about 3 to 4 people every single day. And we also know that for every fatal shooting, there are 2 non-fatal shootings, according to a Vice News investigation. So this issue, the bottom line is this issue is very widespread. This is the tip of the iceberg. There are many other forms of use of force and police contact that impact communities. And so we sought to understand we started to use the data to better unpack what were some of the factors contributing to these outcomes, and how do we address them? So I'm just going to give a brief overview of some of the findings. First, what we found was that Black communities in particular were disproportionately impacted by police violence. The chart that you see here, the red bar is the rate of police violence per capita for Black people. And the gray bar at the bottom is for white people. It's about a 3 times higher rate for Black people. It is also higher for Native Americans, Latinos, and other communities of color. We also found that Black people were more likely to be unarmed when killed by the police. Latinos were also more likely to be unarmed when killed by the police. So not only are we seeing higher rates, we are seeing the context and situation in which force is used is different for Black people compared to white people. We sought to break down this information by jurisdiction. We recognize that there are 18,000 law enforcement agencies across the country, each with its own set of policies and practices, organizational culture, and leadership. And so accountability really starts at the local level. And so by breaking down the data from 2013 through 18, 6 years of data, more than 7,000 incidents of police violence, we were able to identify that there were varying rates of police violence depending on which jurisdiction you are in. Where you are matters in terms of your risk of experiencing this form of violence. There were some communities that have much higher rates of police violence than the national average. For example, St. Louis has the highest rate in the country. Just to give you a sense of what that means, a Black man in St. Louis is twice as likely to be killed by a police officer as the average American is to be killed by anyone, civilian or police, twice as high as the U.S. murder rate. Oklahoma City, also high up there, 1 in 6 homicides are committed by police. But what we also found was that there were communities that had lower rates of police violence, and that in fact, of the 100 largest cities, one of those cities, Irvine, California, the police did not kill anybody in that time period. So we sought to understand what was going on in some of the cities that had lower rates of police violence, or did not have any of these incidents, so that we could learn what could be working in those jurisdictions to scale across the country. What you see on the chart on your right is a visualization of who's impacted by this police violence by race. This is specifically a chart of unarmed people killed by the police during that time period. The red squares are unarmed Black people killed by the police, the orange squares are Latinos, and the gray squares are white people. What you can see here quite clearly is that in major American cities, the vast majority of unarmed people killed by the police are people of color, the majority of whom are Black.
Excuse me, I couldn't read the thing. Is Portland on that list?
Yes, Portland is on the list. Just to give you a sense of where, and I don't want to get too much into Portland specifically, but Portland has a rate of police violence overall that is slightly higher than the national average. However, for Black people in Portland specifically, there is a large disparity that is actually larger than national average. So from a 3 times disparity nationally to a 4 times disparity in Portland. And we'll go into Portland specifically a little bit later. So I wanted to go into some of the causes, and in particular to address some of the narratives that I think many folks have used historically to seek to justify some of the outcomes that I have talked about. And one of those narratives in particular is a narrative around crime. Many folks in this room may be familiar with this narrative, but the narrative goes something like this, that police are using deadly force, particularly in Black and brown communities, because they're in violent communities and encountering violent criminals and having to use deadly force to defend themselves or others from harm. That is the sort of talking point or narrative that we often hear. It is very rare, if ever, that we see data supporting or establishing that that narrative is true, in part because the data did not exist at a national level until we helped collect and build that database. And so we use the data to actually test and evaluate that narrative. What you see here is a chart showing between 2013 and 2018 violent crime rates and rates of police violence in the 50 largest cities of the country. The red squares are rates of police violence. The blue X's are rates of violent crime. What you can see here quite clearly is that the rate of violent crime is not determining the rate of police violence. There are communities with very high rates of violent crime, like Detroit, that have relatively low rates of police violence, much lower than the national average. There are also cities that have relatively low rates of violent crime that have higher rates of police violence. The city with the second highest rate of police violence in the country is the city that I'm from, Orlando, Florida. It is not the most dangerous community in the country. So just to hit this point home a little bit more, these are the 10 cities with the highest rates of violent crime on average between that time period of the 100 largest cities in the country, and these are their rates of police violence. So what you can see here is there's a lot of variation. Within cities that have much higher rates of violent crime, there are some cities that have lower rates of police violence, much lower than the national average. There are some cities that have much higher rates of police violence. Oakland, for example, is a city that has seen historic reductions in police shootings from an average of between 7 and 8 shootings a year just 5 or 6 years ago. This past year they had 0 shootings. The year before they had 1, and the year before that they had 0. So effectively through interventions, many of which we will discuss in detail, they've been able to substantially reduce rates of police violence in a context that many officers may cite as in arguments seeking to justify police violence.
Ms. Samuel, before you move on, I'm curious, do you know how many on this list actually have Department of Justice intervention?
Great question. Oakland has had a Department of Justice intervention, Cleveland and Baltimore. One of the things that you'll find, and a study from Vice News recently established, is that communities that have had Department of Justice intervention have about a 30% reduction in police shootings compared to communities that have not had that intervention. And much of that has to do with the types of changes to policies and practices that reflect best practices in the field and that reflect much of what we will present in this presentation. Okay, so Portland in particular, in part because of that Department of Justice intervention right here, we're able to have access now to a range of data that we didn't have access to before in Portland in particular through the transparency portal that the police bureau maintains. So this is an analysis of the stop data and police shootings data published on the Portland Police Bureau website. This is spanning the 2010 through 2019 time period. And so what we see here is racial disparities increase as the level of police violence or police intervention increases. And particularly with regard to Black people. So Black people are about 6% of the population here, 17% of those stopped by the police, 23% of those shot by the police, and 40% of those who are unarmed and shot by the police. This is not unique to Portland. This is something that you see in cities across the country. That doesn't make it okay, and definitely there are interventions that can address this. Just to hit this point home a little bit more, among those who've been shot by Portland police, 63% of those did not have a gun. What you will see in almost any other developed country is that police are able to resolve situations with people who are unarmed, people who are armed with knives, with other weapons, with other objects, without using deadly force routinely. And yet in the United States, it seems to be that is very far from where the policing profession is in terms of its conduct. This is a breakdown also from Portland Police Bureau website that shows the types of calls that lead to police shootings. What you see, the largest call type is disorder, followed by behavioral health, traffic stops. So these are calls that tend to be, these are not violent crime reports. These are calls that tend to be more routine. And many of these actually involve folks who are houseless. So 50% of those who use of force is used against in the city are houseless. That is much larger than what we see in other jurisdictions, and something that definitely requires its own set of interventions focused on that population in particular. So that's an overview of some of the outcomes data. What we also sought to do was analyze the data with an eye to policy and practices that are being implemented that have addressed those trend lines in other cities across the country. So I'll pass it over to DeRay to talk a little bit about the types of policies that we've considered.
So thanks for that, Sam. With the data overview, there are two things I'd add is that according to HRDAG, which is a research group that normally spends their time with estimating tragedies in other countries, they did a research on police violence, and they estimate that a third of all the people killed by a stranger in the United States is actually killed by a police officer. According to YouGov, a recent survey by YouGov, they noted that this is actually the first year ever where Black people are more afraid of being killed by a police officer than being killed by community violence. So we looked at all the data and we were trying to figure out what structurally can change. We came up with these 10 pieces of Campaign Zero. We are here to specifically talk about two of them, so the police union contracts and then around use of force. But these are the 10 buckets. What we realized and why we double down on police union contracts is that there are structural things within the contracts and with police departments that either encourage accountability or discourage accountability. And they were really clear. We think that the things that we're going to talk about today are pretty common sense solutions. We don't think that they are, we think that they're pretty common sense. We're going to show you clauses from other cities across the country so that you can actually see all of the findings that we'll talk about today are public. They've been public since 2015. We did the Police Union Contract Project and the Use of Force Project in 2015, and they are public. When you go to the site, when we have coded them, and we'll show you on the next slide, we'll show you how we've coded them. But importantly, when you click on any of the boxes, it actually shows you the language in the contract itself, not our paraphrasing. So we believe and we trust people and communities enough to believe that they can read these for themselves and they can reach a conclusion, whether one that we agree with or people might disagree about the conclusion. But we importantly show people the actual language in the contract themselves so that they can understand it as we go through. So we specifically focus on 6 buckets. So the first is disqualifies complaints, restricts delays interrogations. The third is gives officers unfair access to information. The fourth is limits oversight or discipline. The fifth is requires the city to pay for misconduct. And the sixth is erase misconduct records. To give you a sense of the scope of this, so when we did this in 2015, we started with the 100 largest cities in the United States. Not every city in the 100 largest city has a bargaining unit or has a contract. So we did that. It was much harder to do in 2015. So we FOIA'd the 100 biggest cities in one big FOIA. We got the contracts. Contracts are supposed to be public documents. They were not all public. We did a similar thing with the use of force policies at the same time. We got most of them from the 100 largest cities, and that was important. We have recently done a deep dive in the state of California. So we have coded the contracts in the 100 largest cities in California. And then we also have access to 600 other contracts across the country. The size of the city varies with that other set of 600. So we wanted to focus on the 100 biggest because there are 18,000 police departments in the country. With the other 600, they range in cities that are around 30,000 in population and above. So we are in the process of coding the 600, but we chose these 6 areas because when we did our initial analysis, there were a host of things to look at. These were the 6 that we thought were the most structurally impactful in terms of outcomes. Again, my background before focusing on policing was focusing mostly in education and understanding the way contracts existed in that space before, and that was one of the things that helped us believe that something was here to look at. I'll pass it over to Sam to talk about some of the things that we've learned at the macro level, and then we will walk you through each of the categories, what we found in each category, an example of each category, and then our understanding of best practices.
So since we've done this project, there have been a range of researchers that have published papers that have investigated aspects of how police union contracts impact the accountability process. We will cite some of those studies over the course of this presentation, just 2 of them right here. The first is from researchers at University of Chicago Law School. This paper was actually just released in August of this year, where they looked at the relationship between complaints of police misconduct, particularly complaints of misconduct involving violence, and departments entering in collective bargaining agreements. In Florida, in the early 2000s, due to a Supreme Court case, sheriff's departments were only recently allowed to enter into collective bargaining agreements. The police departments there had already been allowed to do that, but this is new for sheriff departments. What the researchers found was that compared to the police departments that were already in these contracts, the act of joining a collective bargaining agreement actually increased the rate of violent complaints of police misconduct by 40% for those sheriff's departments compared to the control group. Similarly, what we see in a researcher at the University of Oxford took our police union contract projects study and found that the provisions, the departments that had more of the types of provisions that we flagged in those 6 buckets, having more of those provisions was associated significantly with having a higher rate of police violence, particularly against unarmed people. So the contract provisions not only impact the likelihood of misconduct occurring, but also very particularly impact the rates of police violence in jurisdictions. So I'm going to go into some of the specific contract provisions that are associated with each of the 6 buckets that DeRay talked about. The first has to do with disqualifying complaints. This refers to provisions within contracts that, through no fault of the person submitting the complaint, actually can result in either the complaint being thrown out or not being able to result in any sort of discipline. So you may be familiar with the provision in the California Police Bill of Rights law, which is similar to what we see in contracts across the country, which means if you submit a complaint and it takes the department longer than a year to investigate that complaint, the complaint cannot result in any discipline of the officers. Well, we actually see in contracts even shorter timelines for this issue. So for example, in Columbus, Ohio, in their new contract, it actually says that investigations have to be completed within only 56 days. Violations of this contract actually are subject to the grievance process, and officers can get reinstated if these terms are violated. Similarly, I'm going to pass it over to DeRay to talk about the second piece.
Can you go back to complaints? So we will talk about this when we talk about the summary findings, but one of the things that's interesting about complaints, and Sam talked about the law, there is a law in the Bill of Rights in California that says that any investigation of an officer that lasts more than a year can never result in discipline regardless of the outcome. Columbus has a clause that you can see clearly is about 56 days, that is 56 days. One of the interesting things that we also track that is not necessarily called out in contracts, but that is a matter of implementation, is that we are always interested in what happens to complaints when they are filed, and can a complaint be anonymous or not. So there are cities across the country where complaints against police officers cannot be anonymous. There are cities across the country where complaints can be anonymous. We'll come back to this in a second, but wanted to just highlight it here because this falls under the disqualified complaints bucket, which is the first bucket that we have. And as you'll see, 31% of this data set, the 100 biggest cities in the country, have some sort of clause that we have tagged as disqualifying complaints. So the second is a set of policies or practices that delay or restrict interrogations. So you can see we pulled out a clause here from Louisville. So in Louisville, it says no member shall be subjected to interrogation in a departmental matter involving alleged misconduct on his or her part until 48 hours have expired from the time the request of the interrogation is made. So most people are familiar with the 48-hour clause, as it's called in most cities across the country. This ranges. So there are some places where officers get 10 days. There are some places where officers get 5 days. There are some places where officers get much more than either of those. And then there's some places where officers are interrogated immediately following an incident. What is interesting about this clause is that the history of this clause is rooted in a purported study that came from the Force Science Institute. So the Force Science Institute is a think tank that was started in 2004 by Dr. Bill Lewinsky. Dr. Lewinsky has a PhD in police psychology. It is his findings that have been cited in almost every notable piece of literature about the history of this rule. What's interesting about the Force Science Institute is that they have never been able to produce a study that has supported the claims that they make. So there have been a set of studies that have come out after the findings have been made that have refuted every finding. There's one study that is continually referenced by the Force Science Institute, and it was actually in the Law Enforcement Executive Forum published in 2008. It is a survey of the research on human factors related to lethal force encounters. This, again, is not a study. It is actually a survey of study on memory that is actually not about lethal force encounters, and the survey is not even about police encounters, but it is a survey of literature on memory that he then extrapolates to lead to the findings around 48 hours. This is important because what the Force Science Institute has consistently maintained is that officers require at least 2 sleep cycles for the adrenaline to drain from their system so their memory can be the best for them to make statements. Again, that is an interesting conclusion to reach, not supported by any piece of study or science that has been found. So this third bucket is about giving officers unfair access to information. We'll talk about this when we talk about the findings or the summary findings. But again, the big idea here is that we believe that police officers should be treated like private citizens, and most of these, or police should not have extra rights that private citizens don't have in most of these basic things. So when we think about Wichita, the police union contract in Wichita essentially says that any complaint against an officer, as you can read the notification, shall state the factual details of the accusations of misconduct, order, regulation, policy, or law, and the names and addresses of all witnesses. Again, we think that that is a really aggressive idea. When complaints are made against citizens, they're not given the names and addresses of all the witnesses. So we are always questioning, what does it mean when officers are given unfair access to information? Again, about half of the police departments in the 100 biggest cities have some sort of clause that does this. They range. So in some places, again, this is where we talk about, can you file an anonymous complaint? New York City is an interesting case in this. So in New York City, if you called the Civilian Oversight Board, the CCRB, technically you can file an anonymous complaint to a police officer in New York City. The caveat is that the CCRB cannot actually charge the officer unless you put your name and address. So what you find in the data is that there's a lot of complaints filed, there's an interesting drop-off, and the drop-off is almost exclusively explained by people who will not sign a sworn affidavit, not because they don't believe what they allege has happened, but because they are nervous about the police getting access to their names and addresses. So again, we would say in this case that if private citizens are allowed to file anonymous complaints against private citizens, that the police would always maintain that they would never be able to do their jobs without tips, and we think that that is a fair conclusion to reach. We would say that that spirit should be held when we think about police officers as well.
So the next category is limiting oversight or discipline. So this is a huge issue where what we're seeing is in these contracts, there are provisions that either affect the disciplinary process, the ability of the police department or community oversight structure to investigate or hold police officers accountable through discipline, that limit the progression of discipline, or that allow officers to get reinstated once they have been disciplined. DeRay is going to talk a little bit about this clause in particular.
So this is a clause that only shows up in a handful of large American cities. So this is what we call the embarrassment clause. We pull this out of the Seattle Police Union contract because it is in the Seattle Police Union contract. This we think is problematic for a host of reasons, but the handful of contracts that this clause appears in, one of the real tensions is that neither of those contracts actually has a definition section. So the word embarrassment is actually not defined. And when we think about that as a matter of both contractual issues, is that what we know and what counsel can explain is that past practice is very important. So the way that this has been operationally used in the absence of a functional definition actually matters more than it should. And that embarrassment is something that we don't believe the side should be able to just interpret at the will of any single incident. So we don't think this clause is a good clause to be in a contract anyway, because we don't know what it. We believe that any modicum of discipline can be deemed embarrassing, but in the absence of a definition, it leaves it open to either past practice or to something that will be litigated in arbitration, and that just, we don't know what the spirit of language like this is if it is not to limit discipline and oversight. Again, this shows up in a handful of cities across the country, almost word for word, exactly as written.
So the other way in which, within this category, we see contracts playing a role is in limiting the powers of the community oversight structure, whether that is a civilian review board or a police monitor. For example, in Austin, in their contract, it says the Office of Police Oversight shall not gather evidence or interview witnesses except the complainant provided herein, or otherwise independently investigate a complaint or other information of police misconduct. The OPO shall not have the authority to subpoena witnesses. So we see there's a range here. Some of the contracts limit the ability or prohibit oversight structures from being able to subpoena witnesses or independently investigate misconduct. Others limit the ability of community oversight structures to discipline officers. We know that there are community oversight structures that very much do have these powers. For example, in Oakland and San Francisco, their oversight structures have the power not only to investigate and subpoena officers, but to discipline them. And we have seen high-profile cases where they have used that power in ways that are consistent with the community's demands. So this is a huge issue. Oversight is a huge issue. We know that communities have, across the country, demanded a stronger community voice in investigation, independent investigations, in the ability to subpoena officers, to require them to testify, to get access to records, and to be able to discipline officers in cases where the police chief fails to actually follow the recommendation of the Community Oversight Board and community members appointed them.
And this is important because, and one of the things we track is that structurally, the oversight function of communities is limited by things that don't seem like they are limiting. So New York City is another good example. So in the charter of the city of New York, the charter says that the police chief is the only person who can discipline, that the discipline powers of the NYPD rest with the police chief. It is that clause in the New York City charter that effectively makes the oversight of the CCRB in New York City unable to do any discipline, but only make recommendations. So when you look at it, you can look at the contract and say there are issues with it. You can look at policies in the NYPD, but neither of those is actually why the oversight function of the CCRB is limited. It is because of a single set of sentences or a few sentences in the charter of the city of New York. So we are always interested in how oversight works structurally. We know that there are some cities, like Sam said, where it is robust, it is aggressive, and we know that there's some places where it is either structurally limited by things outside of the city's control or things that people just haven't recognized are in the city's control.
So another way in which the contracts limit discipline is by allowing officers to appeal disciplinary decisions through arbitration. So it's important to note that not every police department contract, police union contract, has this type of provision. In some places, the mayor or the police chief's decision is final and binding. In other places, police officers can appeal discipline through arbitration, where an arbitrator is selected who has the power. Oftentimes, the arbitrator is selected with the consent of the police union, and they have the power to reinstate officers with back pay. This is something that we've seen, this particular provision responsible for a huge number of officers getting reinstated, even after they've been disciplined. We know that it's very rare for an officer to be disciplined, let alone fired for misconduct, even serious misconduct. And when that happens, we see this single provision in many contracts responsible for undermining those decisions by democratically elected legislators. So this is San Antonio's contract in particular. The decision of the arbitrator shall be final and binding upon the city and the association. Just to give you a sense of this one line, its impact, this is an analysis from the Washington Post on officers who've been rehired after being fired in major American cities between 2006 and 17. In San Antonio, 70% of all officers who've been fired for misconduct have been rehired through that one provision in the contract. That is not unique to San Antonio. In Philadelphia, it's 62%. In Honolulu, it's 58%. DC, 45%. So we're seeing a huge number of officers who are fired getting rehired based on the decision of an arbitrator who is not accountable to anyone, not accountable to anyone democratically elected. And it does not have to be that way. For example, there are many ways in which the arbitration provision in contracts can be changed to allow for a higher level of accountability. For example, in Delano, California, in their contract, it specifically gives the city council the ability to overrule the decision of the arbitrator within 30 days from the date of their decision. There are other measures that can be taken as well. For example, in Indio, California, the contract states that Arbitration is binding for lesser discipline, so for suspensions that are not over 30 days, for reprimands and other forms of discipline, but for firings and for suspensions that last longer than that, arbitration is advisory rather than binding. So there are ways to limit the scope of arbitration that ensure that in very high-profile cases where the community is demanding accountability, where officers have, for example, shot and killed an unarmed person, that the city should have the final say in what happens to that officer. They should not be put back on the force just because of the decision of an arbitrator who's not accountable to anybody.
Now, this is what's interesting about the arbitrator, this conversation about arbitrators, is there's a recent study that came out by Stephen Rushkin, who I think is at, what university is he at?
I think Duke.
At Duke, yep. So that explains the range of options that police departments have used around arbitration. One of the things that we're here to remind people is that though the clause about binding and final is in a lot of contracts, it's not in all of them. And there's actually a lot of room that people have to move. We'd say two things, is that one, we believe in due process. So we believe that people should have the right to appeal. We think that due process is an important right. We are mindful that that the contract language that you saw before this slide is not the only way that due process can live. And notably, school systems often have arbitrators, and then the school board is the final arbiter. So around things like expulsions of kids, certainly around employee issues, we would go to arbitrators all the time. The board could choose to hear it or not, but the board was normally the final arbiter of things. What's interesting about arbitrators too, when we look at this, and there is a research that is not yet published around arbitrators, is that what we find in most cities is that there's very loose management of arbitrators. So arbitrators, if you are unfamiliar with the way arbitration normally works, is that the arbitrator, the person has to be agreed on by the city and by management and the union. They have to agree on the person or the set of people. And there's normally a finite number of those people. So they have been doing arbitration for a very long time. It's a small pool. There's some places where the arbitrator is actually chosen by the labor board. So the labor board maintains a list of 10 people and they sort of rotate. But the set of people who choose to be arbitrators and the set of people who sort of find a niche, like there are people who do school arbitration, there are people who do police arbitration, people who do fire. They're not people who normally do a range. They sort of like specialize, is that they are responsible, a very small set of people are normally responsible for huge sets of decisions. It is like 10, 12 arbitrators make 90% of all the decisions in places. So there's new research that's going to come out about that, but we find, again, in places with arbitration, that they rest on the presence of these rules, and then it is very loose management of anything around the arbitration process.
So another way in which the contracts impact the accountability process is by requiring the city to pay for misconduct in ways that sort of ties the city's hands in cases, for example, in a police shooting. So this is a provision from Minneapolis's police union contract. It requires that officers who are in a critical incident, like a police shooting, requires that they be given not less than 3 days of administrative leave, and that administrative leave shall be considered a fully paid, regularly scheduled workday. So oftentimes in the aftermath of a police shooting, many people have questions as to why officers get paid leave. Why is there not discretion for the police chief to put that officer on unpaid leave? It's particularly as information, oftentimes body camera video and other information makes pretty clear that misconduct occurred. Well, it's provisions like this that really tie the city's hands, require officers get paid leave for 3 days or longer, depending on the language in the contract.
Can I interject for a second? Because I know there's a U.S. Supreme Court case that said that when there's a felony indictment, that a government employer can place somebody on unpaid leave, but that other than that, they view it as a taking and it's a due process issue. I don't know if you address that, but.
So we can we don't have a slide around it, but we can show you cities that do have language where the discretion is up to the police chief. And what we would remind is that, again, in places like in other professions, notably education, the supervisor is able to put somebody on unpaid leave pending an investigation. So, for example, if somebody like hit a kid, slapped something egregious, that the police chief or the superintendent would have the discretion to say that this might be an unpaid situation. Again, if they lost, they'd have to implement back pay, but the discretion is in public jobs as well. But we're happy to have this conversation offline.
So the last category has to do with erasing records of police misconduct. So this can range from records of civilian complaints to records of police discipline. And what we see is that the time period also can range in terms of the amount of time before those records are purged. This is Baton Rouge, their police union contract. It says that if a complaint against an officer is found to be not sustained, then all references to the complaint will be purged after 18 months. If a complaint results in a suspension, so that's sustained and it results in a suspension, it will be destroyed after 5 years unless similar complaints within that time period. If it results in a demotion, it will be destroyed after 5 years. If it involves sexual misconduct, then all records will be destroyed after 5 years. This contract goes on and on and on. There's specific call-outs for sexual harassment where the complaints are destroyed after 5 years. Domestic violence, the complaints are destroyed after 5 years. This has the impact of making it very, very difficult to establish which officers have a pattern of misconduct. We have seen in particular in Phoenix, which last year had the highest rate of police shootings in the country. 1 in 5 homicides committed in Phoenix last year were committed by the police. There were 44 police shootings that year. And an investigation by the local paper there, trying to figure out what was going on, found that this type of provision in their contract had purged 90% of all records of sustained violations against officers. So they were trying to build an early warning system that could help them better identify and predict which officers would commit the next shooting. And they actually found out that they couldn't do that. They didn't have the data because it had been systematically destroyed as per the police union contract. You'll notice some of the contracts do have provisions which say the records are destroyed unless there are similar complaints within that time period. This sounds like they're addressing that issue. In fact, in many cases, it's not. So, for example, we get back records on civilian complaints all the time. The way that those complaints are classified varies. So in St. Louis, for example, we've gotten back records on civilian complaints where there are obvious violent incidents between police, where police are violent towards civilians that are classified as discourtesy rather than use of force. So by classifying the records differently, it's not a similar complaint. There's also not a definition section in the contract, so the definition of similar complaint is very hard to establish. And so, again, in that investigation in Phoenix, they found that they were using this provision not only to destroy records that the contract mandated, but also to destroy records that were in that gray area as well.
Important caveat here is that language like destroyed is very similar to language like removed. So what you'll find in some places is that the city will say, well, no, it doesn't say that we destroy it, it just says that we remove the misconduct. In different parts of the same contract, it'll say something like only data found in the personnel file can be used for XYZ. So if you remove it from the personnel file, you have essentially destroyed it for all purposes that could be used for anything. So that's just a caveat here. And then in cities like Cleveland, we talked about consent decrees before, but in Cleveland, they used to destroy all discipline records after 2 years. As a part of the consent decree, they actually had to change that. So they no longer destroy the records. It is the fix that they put in Cleveland is not necessarily a best practice, but it is better than destroying the record. So that is a case where the consent decree actually forced a change at the local level with regard to this. Again, about 50% of the places that we look at have some sort of thing that erases misconduct. Louisiana is a particularly sort of problematic place with regard to this. And the police officer, I'll pass it off to Sam to talk about this clause in the police officer Bill of Rights in Louisiana, but these clauses are more pervasive than we believed when we started this project in 2015.
So in Louisiana, as per their state police Bill of Rights law, it requires complaints of domestic violence that are unsubstantiated to be destroyed. That means, so it sounds, well, if they're unsubstantiated, why should they factor into officers' disciplinary files? Well, it turns out that it's exceedingly rare for a complaint to be upheld about domestic violence. It's also rare around use of force. Nationwide, only 1 in 13 complaints are sustained. That doesn't mean that only 1 in 13 people who reports what they believe to be police misconduct is lying or it's not police misconduct. It just means the investigation did not sustain the complaint. And that investigation in many cases is conducted with all of these limitations that we've gone over. So effectively what that means is that complaints in Louisiana alleging domestic violence are being systematically purged, and the vast majority of them are being purged because of that unsustained decision.
And the complaint data is fascinating data across the country. We just did a big analysis of the 100 largest cities in California, and we look at LAPD. LAPD kills more people than any police department in the country. And we look at LA data, I think it was 2016, 2017, it was something like 1% of all complaints against the LAPD were ever sustained. And we don't think 2,000 people lied about the LAPD, that seems dramatic to think that 99% of the people alleging something were just making it up. Again, when we met with the LAPD leadership, our questions are always about what is the process when a complaint is filed. There's some places like New York City where the CCRB has a whole process. There's some places where there's a question about like, where does the complaint go? Who follows up on the complaint? Like what happens? So the complaint process is something that the last DOJ was also looking into. It was one of the things that as they ended, they were focused on in their consent decrees. And we had conversations with them about the nuances of a complaint process, but are always shocked around clauses like this that effectively limit what the scope of using data to inform decision-making can be. Again, there's some places, so when we think about things like implicit bias, we are not really talking about implicit bias anymore, besides this comment I'll make, is that we think implicit bias training is really important. But what we found across the country, besides the data being inconclusive about it changing any officer's behavior, is that what happens when you put a set of people through a training and then the data can't be used to actually change anything. So if you do a set of trainings with people, you find out that there's intense racial bias, and then you just put them back in the same communities that they were policing before, we don't think that that makes a lot of sense. Whether you think policing is the best thing in the world or not, that like the data should be used to do something. And what we would say around misconduct data is that if you know that a set of people have a tendency to behave a certain way around a set of people, that police chiefs or mayors or whoever manages the department should be able to use that information to make some changes, even if it's not disciplinary, but make some changes so that we can minimize the negative impact on communities. So here are what we understand to be the core beliefs and sort of best practices. The first is that citizens should have ample time to file complaints, and the complaint process should be clear. Anonymous complaints should be permissible. Again, we would say if the police accept anonymous complaints about the public, then we should accept anonymous complaints about the police. That to not do so seems to suggest that there's a set of civil servants that are beyond the scope of accountability. The second is that investigations of police officers involved in force situations should begin promptly without delay. So there are questions about what this means with regard to Supreme Court precedent. It is interesting that there are appeals courts around the country that are starting to disagree around the Garner decision, which is one of the decisions that has been monumental with regard to officer investigations. Again, most of the delay of officers' interrogations is rooted in statements and claims made by the Force Science Institute. That is where the scientific rationale for this came from before people started to cite what they understand to be the Garner decision, which is a Supreme Court case. And again, that the 48-hour study is not rooted in science. There is no study to support the conclusions that have been made by the Force Science Institute, and those findings have been roundly and routinely found to be false by the scientific community. The third is that during the investigation, police should not be allowed privileges not afforded to private citizens under similar circumstances. So we did not include a long explanation of these clauses because we chose different ones. But there are cities across the country where officers are given breaks during interrogation. So they are given a 10-minute break for rest or for phone calls or for meals. They're given access, like in Chicago, they're given access to a recording. They can bring a recording device to an interrogation. There are hosts of provisions like that, and we actually are not necessarily against those provisions, but we would say if you think that during an interrogation an officer requires a 10-minute break, then we would say the public requires a 10-minute break as well. If you think that an officer should be allowed to bring a recording device to an interrogation, then we don't understand why the public can't bring a recording device to an interrogation. If you think that an officer should be given a transcript of the interrogation immediately following the interrogation and before they can be asked any other question, we would again say that that privilege should be afforded to the public. That to not extend the privilege is to suggest that a set of civil servants deserve more sort of freedom than another set of citizens, and we don't think that that is the principle of government.
So another key piece of this, of these principles, is that citizen oversight is a key form of police accountability. We've seen across the country an effort to strengthen community oversight structures. Subpoena power is now standard in community oversight structures across the country, particularly in larger cities. Now we're seeing many structures that have the power to discipline officers. And this is something that should be taken not as sort of extreme or sort of out there, but is actually considered standard now in the field as a best practice and should be adopted everywhere. Misconduct records should never be erased or destroyed. Arbitration is not necessarily a component of the discipline is not a necessary component of the discipline process, but if it is part of the process, there are ways to limit it so that it does not undermine accountability or the city's ability as a democratic body to actually ensure public safety. So finally, in this police union contract section, I want to talk about the growing movement to address these issues in police union contracts. You know, when we released this study in 2015, there had not been a city that had organized and effectively changed the contract to remove accountability provisions. The conversation on contracts was very focused on issues like pay and wages, traditional collective bargaining issues. But what we were seeing year after year was that these types of accountability-focused provisions, or lack thereof, were being inserted into contracts over the years, and that this was sort of happening under the radar. It was impacting the entire accountability process, but yet it wasn't the focus of sort of the police accountability conversation. And that has very much changed over the years. What we have seen in cities across the country are organizers, city council members, police chiefs, even members of Congress stepping up and calling out these issues in contracts, demanding a different way of structuring these agreements. What we've seen, for example, starting in San Antonio, was a large organizing campaign to get the city to vote down a contract that ultimately did not succeed. It was a 6-3 vote, but was one of the first times that was not a unanimous vote, and that accountability was a key part of that conversation. Joaquin Castro was actually one of the voices calling out for accountability in that situation. From there, we saw in Austin organizers that turned out 200 people to a city council meeting, organized. We went down to Austin, met with city council members, shared some of this research, and we saw for the first time in Austin, the city voted to not approve a contract until many of these problematic provisions were removed. That is perhaps the first time in recent history that has happened. It was a unanimous vote. It was a huge victory for organizers in Austin. It shows that when cities stand up and hold the line in demanding that, accountability is not negotiable. Police accountability is core to protecting public safety. It should not be something that is negotiated away, particularly under the radar in ways that so impact issues that are of core concern to communities, often that they're unaware of through the secretiveness of this process.
And the thing, I'll just say quickly here, and Sam will talk about in a moment, that what's interesting about these provisions, especially with use of force, that when they're present, they actually make police officers safer and communities safer. That there's an idea that if these things that some people understand to be restrictions are in existence, that police will somehow be unsafe. The data actually doesn't support that. But what's interesting about Austin is that in most places, the way labor law works is that whether you're management or whether you're the labor side, and I've been on both sides, is that you can only talk about the nuances of negotiation with your membership. That is the way that most labor organizing works across the country. In Austin, they had a public negotiation process because there was an understanding that the city's membership was actually the citizens of Austin. So they were a part of this back and forth. So like Sam said, the Austin City Council did unanimously vote against the first iteration of the police union contract. They went back to the negotiating table. They renegotiated. They did not get everything that they wanted in the process, but it was an important sort of back and forth between the citizens, the city council, and the negotiating process as a whole. We'll do a smaller dive into use of force. We understand that in your context that the consent decree has changed a lot of things around use of force. We would be remiss to not just go over some of the biggest findings that we have around this process.
DeVay, I'd like to ask the question before you move on. Would you go back one, please? Mm-hmm. And so I'm curious, where did Austin start? What did their contract look like, and what were the provisions that no longer are part of that contract?
Yeah, so in Austin, one of the key provisions that was the focus of the negotiation was the 180-day rule. This was a rule that said that if a investigation lasted longer than 180 days from the date of the incident, not the date that the investigation started, that there could be no discipline of the officer. there was a very high-profile incident where a police officer was caught on video saying racial slurs and using excessive force against a black woman. That video came out after the 180-day mark. Because of that, they were not able to discipline the officer. So that was very much one of the impetus for a lot of organizing around that provision particularly. That provision has been changed now as a result of this agreement. So, you know, in Austin in particular, and what we're seeing across the country, are a focus on the contract as a key part of the accountability conversation. We're seeing this in Chicago as well. So this is definitely I think Portland is part of a growing conversation that is very important to have in the context of police accountability.
And just for context, Commissioner, is that Austin is one of the few in the 100 biggest cities that is actually has a red mark on every single thing that we track. So in Austin, they do give officers, access to all the recordings for interrogations, for instance, like a whole set of things, but they are one of a handful of cities across the country that has a negative mark on every single aspect of something we track.
So, just like we did with police union contracts, we also wanted to understand how police use of force policies impacted many of the outcomes that we presented early in this presentation. In particular, each police department has its own use of force policy. Those policies articulate how and when police officers can use force, how much force they can use in particular situations, what force is reportable or not reportable. But there hadn't been a nationwide investigation of how these policies actually related to the likelihood that officers will use force in the field. And so we obtained the use of force policies of the 100 largest jurisdictions in the country. We reviewed those policies. And what we found was that there were 8 types of restrictions that showed up in these policies that restricted how and when police use force, particularly with an eye to deadly force. Those range from requiring officers to use de-escalation, having a use of force continuum which articulates the types of force that can be used in particular situations, banning things like chokeholds and strangleholds, requiring officers to use a verbal warning before shooting somebody, restricting shooting at moving vehicles. Banning shooting at moving vehicles is something that the Department of Justice has recommended, and even the Police Executive Research Group, and Research Forum, and a range of other law enforcement and community organizations, because it is not only dangerous for the person in the vehicle, but if you hit the person in the vehicle then becomes a missile, which becomes dangerous for everybody else around them. Requiring officers to exhaust all other means before using deadly force, requiring officers to intervene if they see another officer using excessive force, and then requiring comprehensive reporting, that each time officers use force or pull a weapon and point it at a civilian, that is reported. So those are the things that we looked at for each of these 100 jurisdictions. We coded up the extent to which they had or did not have those provisions. Again, this is all public. You can go to useofforceproject.org and click on each of these boxes and see what the language is of those policies.
So what does the blue and the red mean?
The red means they don't have it, and the blue means they have the policy in place.
Thank you.
Yeah, so when you click on the red, it'll show you exactly what the policy says that we flag as problematic.
Can I just ask one question? Is this based on our current use of force policy?
Yes.
Okay.
Yeah, so you're not in this screenshot.
Yeah, they're right there.
Oh, you are in this, yes, okay. I was like, what? Yes, this is
So
video.
I'm going to go into a couple of areas where this becomes meaningful.
And green, just for context, green means that it was updated since we did the first analysis. So on the police union contract one, if it is yellow, like yours is yellow on that one, on the side, it just means that since we did the very first analysis in 2015, something changed in the contract. Same thing with the use of force. Like something must have changed since we first looked at it when we did the initial analysis. That's just what the green marker means.
So this is Portland Police Bureau's deadly force policy. Specifically, it says members may use deadly force to protect themselves or others from what they reasonably believe to be an immediate threat of death or serious injury, or, if necessary to prevent escape, a member may use deadly force where the member has probable cause to believe the subject has committed a felony involving the infliction or threatened infliction of serious physical harm, and a member believes the subject poses an immediate threat of death or physical injury to the member or others. Now, there is something important missing from this policy, and that is a requirement that officers, in addition to those threat elements being present, that deadly force is necessary to address those threats, specifically that there's no other means to address that threat available to the officer at the time that could effectively deal with the situation. What we see in other policies for about 40% of departments in the country, this is Stockton, California's policy, their deadly force policy in particular articulates that that is very much a condition that has to be met in order for officers to be justified in using deadly force. So for example, it says for Stockton, firearms may be discharged in the performance of a police duty only under the following circumstances: when necessary in defense of another person's life, when all reasonable means have failed or are impractical, when necessary in the defense of an officer's life, when all other reasonable means have failed or are impractical. Siri doesn't like that. When necessary to effect the capture of or prevent the escape of or rescue of a person whom the officer has reasonable cause to believe has committed a felony involving the use or threatened use of deadly force, when all other reasonable means have failed or are impractical. So again, this is explicitly articulating a standard that officers are not justified in using deadly force unless all other reasonable means have failed or are impractical to deal with the situation. These policies are not just words on a piece of paper. They actually matter quite a bit. So, for example, we looked at the relationship between these restrictions and the rates of police violence that I articulated in the beginning of this presentation. It turns out that police departments with these restrictions are significantly less likely to kill people than departments that do not have these restrictions in place. Departments that require de-escalation are 15% less likely to kill civilians. Departments that require officers to exhaust all other reasonable means before using deadly force are 25% less likely to kill civilians. And when we perform a statistical analysis on this data, accounting for a variety of control factors like the demographics of the jurisdiction, the number of police officers on the force, the number of arrests made, it turns out that from going from 0 of these policies adopted to all 8, it is associated with a 72% reduction in killings by police. That is a huge impact.
Now, the reason why we bring this up here is that policies change, and we'll talk about this Oregon law, and Council would love to know your take on this, but policies change much more than the contracts change. So the contracts change in cycles, we can track it, we know it. Policies change, and there's not necessarily an announcement for it. So New York City, again, is a good example today, is that most people know that Pantaleo, the officer who killed Eric Garner, was fired by the NYPD. What most people don't know is that chokeholds are banned in, so before I say that, the difference between chokeholds and strangleholds is sort of a wonky thing for most people. A chokehold restricts your airway, like your Adam's apple. A stranglehold restricts the muscles around your neck. So the NYPD had always maintained that they did not choke Eric Garner, but that they strangled him because strangleholds were not banned by the NYPD. Chokeholds were banned by the NYPD since 1993. They were banned when Eric Garner was killed, which is why the NYPD had always maintained that they did not choke Eric Garner. What most people don't realize is that right after Garner was killed is that the administration actually did 3 important things from a policy perspective. Is one, that they lifted the ban on chokeholds, so chokeholds are now permissible by the NYPD. So when you look at the policy, the way that it reads is that it says chokeholds are banned on one page, and the next page it says in italics that all of the things that were banned on the previous page can be deemed permissible by a use of force panel, which didn't exist before. And then when you ask who's on the use of force panel, it is a deputy commissioner and then his 3 subordinates, which is effectively not banning it. The second is that they lifted the ban on shooting into moving vehicles. And the third is that the NYPD lifted the requirement that force be used as a last resort. So again, these things happened very quickly, very quietly. People didn't pay attention to them. They happened, there's no announcement for them. Whereas contracts change in cycles that we normally can follow. So we always are just mindful of this. I'll just lead into this. So Oregon has the most permissive law around deadly force in the country. So Sam skipped the slide, so you have to go one back. So we just pulled this part of the use of force policy, the use of force law out in Oregon because it is the most permissive law in the country around use of force. So we understand how police departments in Oregon have struggled around force because this law is not necessarily helpful. But what the law essentially allows is if a police officer thinks that somebody is about to commit a felony, they can use deadly force. If they think somebody has just committed a felony, they can use deadly force. And then there's a provision around they can use deadly force if the person is engaged in escape in the first degree. So again, this is a very, very permissible law around force in the country.
Yeah, and just to hit this point home, we know that local jurisdictions can set use of force policies that are more restrictive than state law. They have the authority to do that. They do that all across the country, not only more restrictive than state law, but also more restrictive than the minimum constitutional floor that is set by Supreme Court precedents in Tennessee v. Garner and Graham v. Connor. So What that means is that, in prosecuting an officer for deadly force, they're held accountable to the deadly force law. But in deciding whether that officer should remain on the force, the city has the jurisdiction to set higher standards than the minimum floor set by state law on this issue. And we see that happening all over. For this law in particular, one of the reasons it's particularly egregious is the use of or in so many of these provisions. So it says that an officer may use deadly physical force only when the officer reasonably believes, and then if you look at Section B, the crime committed by the person was kidnapping or arson, escape in the first degree, burglary in the first degree, or any attempt to commit such crime. So if somebody is suspected of committing any one of those crimes, that alone is sufficient justification for the officer to use deadly force under state law. That is wild. You can imagine many people may be falsely identified or profiled as being, a suspect in one of these cases. It opens them up to being a potential victim of deadly force, regardless of the threat that they pose in that moment, regardless of the threat that they ever posed in the past or that they would pose in the future. And then DeRay touched on this a little bit. Yes.
Commissioner, did you have a question?
I think you answered my question. Thank you, Commissioner. We're not preempted from having a more restrictive local policy.
That is correct.
So that those provisions would just be related to criminal prosecution of the officer. Is that where that works?
That would be state law on use of force, so for like state police, et cetera.
Okay, thank you.
But cities and counties can have a more restrictive policy, but not less.
Thank you.
So DeRay touched on this a little bit. One of the things that we've heard from many folks who have resisted adopting some of these best practices, despite all the evidence that they can save lives, is this idea that they put officers in danger or somehow handcuff officers and prevent them from defending themselves or others from harm. There's no data at all. There's no study establishing that that is true. It relies purely on the assumption of people who are hearing that comment. We actually tested this assumption using the facts and the data, and what we found was that officers in jurisdictions that have the most restrictive use of force policies are actually safer than the jurisdictions that have less restrictive policies. They're less likely to be assaulted in the line of duty, less likely to be killed in the line of duty. Also that there are similar crime rates across jurisdictions, regardless of the restrictiveness of the use of force policy. So it does not result in some sort of a crime rate wave. It does not put officers in danger. If anything, it makes officers safer. And then finally, predicting future misconduct. We talked about the role that data on past complaints, past misconduct, past use of force incidents can play in identifying through an early warning system which officers might be at risk of using excessive force or committing misconduct in the future. The research and the science on this has advanced significantly over the past several years. Now we can actually design models that can effectively predict which officers will be involved in the next shooting, which officers will commit excessive force next. There are predictive models that can do this, but they rely on being able to use data on complaints, both sustained and unsustained. They rely on being able to use data on past use of force incidents going back several years, being involved in a misconduct lawsuit, and information on the proximity of officers to other officers that have those records. One of the things that has recently been found through researchers in Chicago at the Invisible Institute is that officers who are placed under the supervision of or on the same patrols as other officers who have a track record of misconduct, those officers are then over time more likely to exhibit the same behavior. They're more likely to be named in a future complaint. They're more likely to be involved in a future shooting. And that means that misconduct spreads through departments in a way that that tracks almost like spreading a disease over time. So folks in public health use these models to track the spread of disease. What it shows is that misconduct starts actually in a relatively concentrated area, but because those officers are not held accountable, in part because of the impediments to holding officers accountable in contracts and in other systems, that misconduct spreads as those officers are then promoted through the department, are socializing other officers into that type of behavior, such that by the end of this period of the study from 2000 through 2017, over that 17-year period, that there is a huge misconduct issue throughout the department that started relatively small but grew over time because these accountability systems were not effective in rooting out those officers in the beginning.
So two things just to add. One is around this specifically. So there are some cities around the country that have, in the contract, have restricted the use of personnel data to either informed discipline or reassignment, and things like that. And what we would say is that we don't understand it doesn't make sense to collect all this data around force being used and not be able to use it, at least in things like deployment. So if you know, for instance, that Officer A disproportionately has complaints come when they are on the north side of the city, that not being able to use that data independent of like a complaint, independent of a lawsuit, to use that data to reassign them, that doesn't make sense to us. And there are some cities that have negotiated away their ability to do things like that. And we would say that the purpose of the data is actually to use it to inform decision-making, and we are open to how that data is used to inform the decision-making. We feel pretty strongly that to negotiate away the ability to use it at all doesn't actually seem like it makes much sense for anybody. It doesn't seem like it makes much sense for management, and the police might be put in situations where they are just not successful, and that doesn't seem to make sense at all. What's interesting about discipline data is that it's often discipline data that we find data that we don't find other places. So in cities across the country, it is complaint data that will tell us who the officers' partners were, where they normally are around the city, what type of weapons they have. That data normally is not captured in a police department's EIS system. So that is interesting. So when it gets destroyed, as we talked about before, we're not only losing a record of misconduct, we're losing a host of other information about the officer that can be used. I'll go back can you go back to the Oregon law, and just wanted to define for you what's in this. If you look at 1B, the crime committed by the person was kidnapping, arson, escape in the first degree, burglary in the first degree, or any attempt to commit a crime. Escape in the first degree is defined in Oregon State Law 162, 165 as a person commits the crime of escape in the first degree if, and there are two, aided by another person actually present, the person uses or threatens to use physical force in escaping from custody or correctional facility, or the person uses or threatens to use a dangerous or deadly weapon escaping from custody or correctional facility. Now, the problem with that is if you're in police custody and the police officer just says you threaten to shoot him, kill him, hit him with a rock, and they kill you, you actually are never able to present your case that you did not threaten to do those things. And we, again, think that this language is so permissible in a way that we have literally not seen in any other place across the country.
So here are some resources with the data that we presented in the presentation. If you're interested in doing a deeper dive, that concludes the presentation.
One more thing I wanted to say, Council, you had a question around the pay for misconduct. So there are places like Anaheim, for instance. In Anaheim, the way that the language 54.1 in the police union contract, it allows for, under certain circumstances, for the discretion around leave to be found with the police chief, for instance. There are other clauses that are more restrictive and other clauses that are more permissible. So there's some places where not the union, so in a lot of places around the country, it's the union representative or the union pays for the legal fees, like that is like what bargaining unions do, right? There's some places where the city actually has to incur the legal fees for all incidents of killing, and that is like a negotiated thing. So it is not the union money, it is the city actually represents the officer. So we lump all of those into that category of paying for misconduct.
There's also a lot of discretion around where that money comes from. So in some jurisdictions, that money comes out of the police department budget, whether it's a misconduct settlement or legal fees. In other jurisdictions, it just comes out of the city's general fund. So it really ranges, and there's some leeway and flexibility for the city to decide, who should be held accountable financially for those decisions.
Thank you so much for that very informative presentation. I had a question around data collection. So a lot of the data is based on complaints, right? I think I heard you say some of the data was collected through the complaint process. And so I'm curious as to if you have noticed whether there's a trend that less complaints are filed, and what the analysis would be around a drop in the complaint process.
So there could be a number of explanations for a drop in complaints.
Before we do that, though, in terms of just the general data, so the data that we have around police union contracts was collected from reading and coding all the police union contracts. So not complaint data. It was, we got copies of the the contracts. We work with a set of lawyers and volunteers to code every clause that we found, and we mapped it. So we did that for the 100 biggest cities, and then we have a separate project around California. We did it for the 100 biggest cities in California, and we have an outstanding set of 600 that are cities around 30,000 residents or citizens and above. So that is where we got most of that from. The data around people killed, so as you probably know, if you get killed in the United States and the newspaper doesn't write about you, you didn't exist in the data set. So the data that Sam started talking about with mapping police violence, that was from a host of sources, because up until very recently, and Sam can talk about that, the federal government has only begun to have a mechanism that is even remotely robust around capturing the number of people killed. So there are times in Florida has reported that they've killed 0 people by police, and we know that like the newspaper reports show that that is not true, because at the state level and around the country, the mechanism for collecting it was just really dry. And this was a conversation that we had with the Obama administration and a host of people. With the complaint data, and I'll pass it back over to Sam, is that the complaint data is interesting because in so many places, so few complaints are sustained that it is hard. You know, like in LA, it was 1% of complaints were sustained in 2016-17. So really we are trying to figure out what do we learn from the process, because we're not learning much about the complaints themselves.
Yeah, I mean, so, just to build on that, LA, 1% sustained complaints for use of force specifically, 0% for bias-based policing complaints were sustained. And so complaints can go up or down for a variety of reasons. It could be that you have fewer complaints because there's less misconduct. It could be that you have fewer complaints because the process has been made more difficult to submit a complaint. So there are a variety of reasons to explain it. It's very difficult. So you can't attribute a drop in complaints to a drop in misconduct necessarily. However, what we do know is that the complaints that are received are informative of understanding which officers have a record of misconduct, which officers may be involved in future misconduct, that data is very valuable and predictive scientifically of that future conduct.
And what's interesting about the complaint process is that this was actually something that the Obama DOJ was really focused on. So as a part of their consent decree process at the end, and we met with their team about this, is that they would actually go into cities and they would force a city to map the complaint process. Because when you go into most cities and ask the police chief, like, tell me what happened, when this person files a complaint, tell me what happens, you just don't know, they're like, well, somebody investigates it. You're like, well, who? When does the person investigate it? Is it internal affairs? Is this like a pet project? So in the city of Baltimore, for instance, and they have recently changed this, but in Baltimore, the only way to file a complaint was to walk the complaint into the police station. Nobody's doing that, right? So what we found, and what the DOJ found when they came in, is that people are walking in complaints. The complaints got destroyed from the police station to central headquarters, right? So it's those sort of things that are like squarely process issues, and that's what is most important when we think about complaints, given that the sustain rate is so low.
I have a question, Mayor. Thank you for your presentation. You highlight some work that's happening in Austin, Texas, and I was listening intently to your presentation, but I guess I'm not clear where they are today. So what have they accomplished, and what is their future plan from the council's perspective in terms of further change they're seeking?
Yeah, so they removed, they changed the provision around the 180-day rule, which was really the focus of so much of the organizing there. That has been changed from the contract. It is no longer that complaints that are 180 days after the incident can't result in discipline. So they abolished that impediment to accountability. Moving forward, there's organizing around some of the other provisions in the contract. As we said, Austin has a series of provisions that impose some of the barriers to accountability that we described. And so, this is an ongoing effort, but they were able to win on that issue. They also won on a stronger accountability structure because in the contract it articulated the independent police monitor, I believe it's called, the powers of that, and I showed you that it limited their subpoena power and all these other issues. So they say they won a little bit on that issue as well. So this is something where they were able to change the contract for the better. The organizers are still focused moving forward now on use of force policies while the existing contract is in effect. And then we'll come back to the table next negotiating session and make further progress.
And again, in Austin, they have some of the things that they were not able to change, but is on the table, is that as a part of their contract, officers who are being investigated have access to all statements and all witness information before any interrogation can happen. Again, which we would say is a privilege afforded to the police, not afforded to the public. So those are some of the things that they are working on. Weren't successful in this round of negotiations. They focused not almost exclusively, but a lot of attention was based on the 180-day rule. And then the Portland contract explicitly says there can be no civilian oversight. It's not like hidden in the contract. It was explicit before, and they've worked on that.
And you may not know the answer to this, but we heard from counsel at the beginning of the presentation about Oregon law and the process we have to go through negotiations and possibly interest arbitration. What was the mechanism for finalizing a contract in Austin?
Yeah, so when the city council unanimously voted against the first iteration of the police union contract, both parties had an interest in resolve. Nobody wanted to go to arbitration or impasse, whatever it's called in the respective place. So they came back to the table. I think that, everybody went into negotiations understanding that there would be a give and get. Nobody went in sort of with a doomsday sort of idea around negotiations. I think that the first round of negotiations was very lopsided, and I think that that is why the city council unanimously voted against the police union contract that came forward. I think the police understood that, like, it was hard when you heard the police justify the 180 days from incident, and that is really aggressive. So a lot of the women's rights groups came out about that. Like, imagine if a woman was assaulted by a police officer and just didn't say it until the 178th day, then if it wasn't resolved in 2 days, there was nothing that could happen. Is that people understood that it just wasn't a defensible clause, so they backed down around fighting to keep those things in. I think that why it got resolved is that everybody wanted it to come to resolution, and they agreed that they would just fight some of the fights at the next negotiation.
Thank you.
Chief?
Thank you for your presentation. Going back to the slides in the beginning, when you talk about the data that kind of formulated the project, pretty much the groundwork, there's a lot of focus on those who had guns and those who did not. And I got a couple of questions, or maybe just one question. Recognizing that the loss or taking of human life is the ultimate use of police authority, and also acknowledging that laws and systems, specifically criminal justice systems, vary across this country. When looking at the data, did you also look at or discern whether or not the shootings, the officer-involved shootings, were deemed lawful and in policy and procedure, and make a comparison to this, or did you look at all shootings across the board?
So it's very difficult to make those comparisons, in part because the sample size of officers who've been disciplined or charged criminally after a police shooting is so small that we actually can't draw conclusions based off of that. And that is an indictment of the system. And so nationwide, in 98% of all cases where somebody is killed by police, no officers are charged. In 99.5% of all cases where somebody is killed by the police, no officers are convicted. When officers are convicted, they get a lesser sentence than civilians of the same crimes. That is the structure. That means that our sample size is very small for being able to draw conclusions. It is not much better when you look at administrative discipline either. It is only slightly higher than that. So that's part of why we couldn't go into that data.
And you saw from the other slide is that even in places like San Antonio, where the police department has disciplined the officer, when 70% are rehired, then it is a question of how we make conclusions, because one person could look at that and say, well, that was the police department making a decision around force, whether it was permissible or not. And then the arbitrator overturns it, and that wasn't the department's decision, that was the arbitrator's decision. So again, the sample size makes it complicated to draw those conclusions.
Thank you.
Great. Any other questions, Commissioner Fritz?
Thank you. This has been really interesting. I very much appreciate your expertise and the Mayor and Commissioner Hardesty for having this session. I really appreciated the difference highlighted on the police use of deadly force policy and the Stockton police of deadly force policy. And on some of the color coding, you've got, yes, we have a policy, no, we don't. Do you have other specific examples of policy where we have a policy, but it might be better if we reworded it? And if so, could you send them to the chief, please?
Yeah, absolutely. We'd be happy to do so.
Yeah, and that chart is not a do we have it or do we not. It is what is the problematic language. So when you click on it, it
Okay.
will literally show you. So if you go right now, and there's a question from Commissioner about Austin. If you go and click on the Austin box, it'll show you the language that says that officers get access to all statements before they get interrogated. We have some of the best practice language, and we're trying to code that. That is the next part of the project. So there are some cities that do this incredibly well, like from a structural perspective, and we're trying to make a space that just has all of those in one place as well.
And
That
for
is really helpful, because obviously we can change policy without bargaining, and
Yep.
just the specific examples, and when you point it out, it seems really clear that the Stockton one is better.
Yeah, and
So there may
absolutely,
be some
and
discussion
use of
on that.
force, that's at useofforceproject.org. You can see for Portland specifically the things that the police department has in place, what it doesn't have in place, the language of the policy that's reflected in that. We have a model use of force policy as well that borrows from some of the best practices that we've seen from all 100 departments that we've looked at and puts them in one place. So there are a lot of resources out there that could be helpful to improving the policy.
And this is a conversation, and Chief Outlaw, correct me if I'm wrong, I don't think you're in Lexipol City here.
What's that?
Lexipol, you're not a Lexipol City.
No, we're not.
No. So there is, one of the things that we found that was surprising to us, and we found this out, I guess, in the last year. So when we did this use of force project, we were trying to figure out why is the language in use of force policy similar all across the country from random departments that have no seeming relationship. We understand why some of the contractual language is the same because part of organizing is like a national organizing unit will help the local affiliate. So that makes sense to us. But there's not the same sort of thing around use of force policies. And there is one company in the country, Lexipol, that writes the policies for about 3,000 of the biggest police departments in the country. They explicitly write the policies. Luckily, your city is not one of them. They write the majority of the policies for police departments in California. What's the percentage?
95% of all police departments in California.
There's one company that writes us policies. So and the policies are not best practices according to civilians when we think about this in terms of saving lives. So that has been something that we learned a lot from to see why they were so similar.
Oh,
Mayor-
please, Chief.
I just have a clarifying question. Do you know whether or not the Stockton policy was changed before or after the California law required agencies to add the necessary language in there?
Before.
Okay, thanks.
Commissioner Fish?
Before we had the presentation, we got some clear guidance, both from you and Commissioner Hardesty and from legal counsel about what we were and were not doing today, and we're
Yes.
certainly not here today to have a public conversation about bargaining strategy or legal approach. However, I have a ton of questions which flow from this presentation. So, Mayor, I hope that one next step is that Heidi Brown and potentially others come around and brief council offices. I think there's a debrief of this presentation, and there's questions that are best raised in private since they go to things like strategy and how we may be proceeding with our labor negotiations. And I hope we can begin that process in the next 2 weeks.
Commissioner?
Thank you, Mayor, and thank you, Commissioner Fish. So I'm curious, if you were building a police department from the ground up today, based on your analysis of contracts across the country, what would it look like? What would be the absolute minimal requirements of that contract?
Well, I mean, that's a difficult question because it builds in the assumption that we would be building a police department.
Well, be that as it may.
I would say the first thing I would do would be, before deciding to build a police department, doing an analysis of where those resources would be best spent. In particular, looking at, how many resources should we divert into mental health first responder teams like they have just in Eugene, Oregon. As an approach to issues of mental illness, substance abuse, where are we spending money in homelessness, which is responsible for the 50% of all use of force incidents involve folks who are houseless.
I have to correct you. I'm not sure that statistic is accurate.
That's on the Portland Police Bureau website from
Is it use of
2010
force
through
or
19.
is it arrest?
Use of
data?
force.
And arrest.
We
And then-
use publicly available data from Portland, and we actually double checked it last night. So it actually goes a little bit over 50% in the most recent quarter. I think it's
Recent quarter was 58%.
Yep, and when you go to some previous quarters, it's like 49%, but it is almost perfectly around 50% based on the Portland data.
Okay, thank you.
So I think that's a huge chunk of the issue right there. that being said, I think on the how are we looking at the systems and structures that already exist and how they can be changed in ways that save lives, I think number one, it would be removing these barriers to accountability, and in their place, creating an accountability structure that works. I mean, we should be thinking about how do we empower the early warning system to more effectively predict misconduct and have those decisions or that data actually stick. Like, how do we make sure that the best science is being used and how to prevent these incidents moving forward, rather than thinking about how can we limit the use of this system and the implications of the system. I would be thinking about how are we looking at arbitration and other issues in ways that can ensure that officers who, particularly in some of the most egregious cases, serious cases of misconduct, police shootings, that the city has some sort of power to make sure they're not on the force. I mean, at minimum, if you're paying their salary and if the public is holding you accountable to ensuring the public safety of the city, you ought to have the power to hold them accountable, the officers accountable, to not engaging in practices that endanger public safety. So I think those are some basic, bare minimum, common sense things that should be happening.
And then
Thank you. I also just want to add that we are working on the Portland Street response that really will address the whole issue of who's the appropriate first responder. And so partnering with the mayor, we are really being intentional about how that process works. And so just know, yes, Eugene has it going on with Cahoots, but we're going to have it going on too, because we're going to be implementing this new vision.
Very quickly, what I'd say is a reminder that the end of crime is actually the end of poverty and the end of addiction. So we see all across the country is if you actually want crime to decrease, and it actually is attacking things like poverty and addiction. And New York City is a great example of that. So we do have data about this, but when Pantaleo was fired in New York City, the NYPD they underwent a slowdown, which is when the police just say sort of explicitly that they're not going to arrest people anymore. Both times that a slowdown has happened in New York City, crime has decreased. And it is one of those things where New York City is a proof point in the idea that a decrease in arrests does not lead to an increase in crime. In both instances where they have undergone a slowdown, they've done it twice since protests began. In both cases, crime has decreased. Sam, what were the percentages of the decrease?
So I believe it was around 20% over the previous year average, and it was also down versus the previous weeks before the slowdown happened.
So that's like a reminder. So again, when we think about the percentage of homeless people, houseless people killed in Portland, it's like the end of that sort of force being used is actually the end of homelessness, right? Like this is actually a part and parcel. The second is that this core belief that if it's good enough for the police, it's good enough for the public. We think that is a sort of basic idea that if the police, again, around tips, if the police will get anonymous complaints from the public around crimes that happen, we don't know why you can't file an anonymous complaint against a police officer. We think that's like a basic. We don't think that's radical. We don't think that's revolutionary. We think that's a pretty simple concept, but one that is not in place across the country. Another bar that we have is that would this be okay for similar public servants or any public servant? So I spent my career in education and managed human resources or human capital for a $1 billion organization. We had 80,000 kids, 10,000 staff, employed as many people as the city of Baltimore itself. And it would never have been okay if I told people that we just erased the misconduct records of teachers. People would say that that was unfair to their kids, that we needed to know if people had hit kids before or had yelled at parents, that would have to be that even if we didn't use the data immediately, that we should know when we thought about placement. So I remember disciplining teachers who had hit special ed kids, and it was like, before we fired them, it was like, well, we knew that you are a threat to special ed kids, that this is actually a real challenge. So that was one. The third is that we know actually, and we're not Pollyannas about this, we understand that most of these provisions actually came not because police, like the first use of force, the first Bill of Rights in the country was in Maryland, and that did not come necessarily from police asking for these outlandish clauses. Really, it came from the police department in Baltimore. The General Assembly felt like the mayor was unfairly targeting the police in Baltimore around a particular dispute. And there was a real disagreement about whether the mayor was right or not in disciplining the police department in Baltimore. And that actually spawned what we now call the Bill of Rights across the country. So it actually didn't come from a nefarious perspective. It didn't. And the Bill of Rights in Maryland that spread across the country. And we know that as a part of the negotiation, because so many of these clauses are cost neutral, we've seen cities across the country just sort of say, well, I'll give you this. I'll erase the misconduct records because it costs nothing in exchange for something else. And that is sort of how it works, because anybody who's been a part of negotiations, you know that most of the things that people fight about are money. Like it's either health insurance or salaries. So most of the provisions that we talk about today are actually cost neutral. They are not cost neutral with regard to people's lives, we believe, but they are financially cost neutral, and we also understand that. The fourth is this idea of who gets to decide. So we would say the way that most arbitration clauses work is that the police department, the mayor, city council actually isn't the decider, and that we think that if the people elected aren't the people who have ultimate authority and accountability, then what is the purpose of democracy? And then the fifth is that there's no reason to have data if you won't use it. So we would build a system that had collected data and used it not necessarily only in discipline, but definitely used it in a host of other things that, again, we would say other sectors have understood. So I knew when I had data around, if you always had parents complain about you as a first grade teacher, I wouldn't put you in first grade because it just didn't make sense, right? Same sort of thing. So when you negotiate a way to use that data to serve people better, then we don't understand why those things exist.
Commissioner Fritz.
Isn't there a state law that says that we can't, didn't we try to change the law so that we could be the final decider?
Yes, Commissioner, there was a proposal before the legislature last session that would have authorized in police contracts, or in police departments rather, that if the police department had a matrix for the discipline that would say you committed X rule violation, then you get Y discipline. So if you have that system in place, that then an arbitrator would have limited authority. They would be able to review whether or not the discipline occurred, but the level of discipline would not be able to be reviewed. So if you determined that termination was the appropriate and you were following a matrix which would be bargained with the union, then that would be the discipline level that would exist.
And we didn't get that passed, right?
That did not pass. It went quite a ways, and I don't know if it'll be reintroduced this session.
Thank you. Then I just want to clarify about the anonymous complaints. Isn't there something about the right to face your accuser? So how?
Well, I can clarify. Commissioner, at the city, we take complaints from anybody. I think the only issue with anonymous complaints is it makes it more challenging to uphold if a discipline is challenged through the grievance process or however, when you're looking at due process and whether we can uphold it, it's going to just be it makes it more challenging when somebody's anonymous. Because we can't ask them follow-up questions and things of that nature. But
we
it
do
doesn't
take
mean,
them.
we do take them, and we do investigate them. And if we have, particularly if there's other evidence that supports the complaint, that makes it more helpful and easier to proceed with action where we find rule violations.
Well, just a point of clarification, the website to submit a complaint online does require a first and last name. So I don't know if that means that you have to put anonymous for first and last name or what it is, but it's not really clear for the community member how they could submit a complaint anonymously, at least if they're using that option.
I'm curious about, thank you. I'm curious about whether you came across any model whistleblower protection policies in your evaluation of contracts across the country.
So before we go into that, just one thing for council is we would push a little bit about this idea that it makes it harder when the complaint is anonymous, because unless you think that logic extends to the police department using anonymous complaints from the public.
I think it does. I think no matter what, that when you're looking at trying to hold somebody accountable, if you have the person who actually filed the complaint, so if you have a citizen filing a complaint anonymously, the police investigate, again, if they find other evidence of the crime, then it's easier to proceed, and that's the same thing I'm saying with misconduct. If we find other evidence, it makes it easier to proceed. It doesn't mean we can't, but just that it's going to be much harder to uphold. And same thing with citizens. If there's a complaint about a citizen committing a crime, if we have an actual complainant who's willing to come forward, it does make it easier for the district attorney's office to proceed on the criminal charges as well.
That makes sense. And again, Commissioner, we would just say that logic is one that is used, and the police have not dismissed anonymous complaints, but they understand that there's a risk involved and they're willing to take that risk. And we would say that risk is something that we would encourage cities to do around the police. So in the same way that if I said a police officer stole money from 7-Eleven, that alone probably isn't enough, but it's enough for somebody to go do an investigation. In places where you can't even make a complaint like that, how would the investigation begin is our push.
To your question about whistleblowers, there were some contracts, and I can send you a list of those cities that did have provisions protecting whistleblowers, people who report misconduct. And I think this is really the core of it. I mean, as a union, if your goal is to protect your members, we understand that that's the goal of unions, that's fine. But there are ways to protect your members that do not encourage or shield those members who commit misconduct. Instead, you could be negotiating for provisions that shield officers who report misconduct, who shield or provide protections for officers who are doing the right thing, who are acting in ways that actually are things that the department might want to incentivize and promote, rather than exclusively using so much text in that contract specifically to defend officers under investigation for misconduct.
Thank you.
Very good. Anything else? Any final words? Gentlemen, Commissioner Hardesty.
I just wanted to thank each and every one of you. I appreciate you being here, Chief. I appreciate the community showing up to be here and to hear this. This is an ongoing conversation, only 2 decades in the making. And so I am grateful that we've had an influx of really good information from national best practices across the country, and it will give us good information as we start preparing for next year's opportunity.
Gentlemen, in closing, I want to thank you for being here. And of course, best practice for us is all relative because we have a contract in place, we have policies in place, and we will take up good faith bargaining with the PPA under those circumstances. You have given us a lot of good information. I think it's going to create some provocative conversations both in the community as well as in the Police Bureau, and I thank you for being here.
Thank you.
Thank you.
And we are adjourned. Thank you.